right after 11. We want to get this going. So while you guys are working on that, we'll just do introductions. I'm Naomi Valentine of Community Action Partnership in Kalispell, Montana, and I'm the room host for this breakout session. We're really happy to have everyone joining us today. Again, just a little public service announcement for everybody. Please mute your lines. Use the chat function for any questions or comments that you might have. And we will try and address all the questions at the end of the session. Just a few housekeeping items. All these sessions are being recorded. Make sure your video is turned off while the presenters are presenting. Just click the chat icon and you can enter your name, organization, location, and you can turn your video back on during the question and answer time. Each of you should have received a whiteboard paddle and marker in the mail. If you find something inspiring, exciting, or new, write a quick adjective on the whiteboard, hold it up, and let us know during the Q&A time at the end of the session. And so with that, how are we doing with the little housekeeping there? Have we got the slides working?
They're working, but I can't figure out how to get the middle slides off the left margin. Anybody have ideas?
I think I've got everybody here. Okay, so as you ladies are doing that, I'll go ahead and turn it over to you whenever you're ready. Go ahead.
All right, everyone. I'm sorry. This is Rachel. We were just having a little bit of slide issues here and trying to see if we could get this fixed, but we're just going to go with it. So I apologize for us not having the correct view, but we're okay. Good morning. I want to say thank you so much for being here with us this morning. My name is Rachel Turnbow, and I'm the Disaster Legal Services Program Coordinator at Montana Legal Services Association. My pronouns are she and her. I'm coming to you today from my home in Helena, and I wanted to acknowledge that this is land that belonged to the Salish and Kootenai people prior to some very problematic treaties that they entered into with the United States government. There's a long, rich history there, and I won't pretend to know all of it, but I want to just say that notably the Hellgate Treaty with the United States in 1855 contained some very serious translation problems. In negotiating this treaty, the tribal people came to the meetings assuming that they were going to formalize an already recognized friendship with the United States government, while non-Indians came with the goal of making official their claims to native lands and resources. So I want to just acknowledge that we are on that land today. As the Disaster Legal Services Coordinator, I also coordinate the Montana Eviction and Intervention Program, which we're here to talk about today. I'm joined by Amy Hall, who is our housing attorney at MLSA, who will be talking about the legal aspects of an eviction and some of the things that are of particular importance when talking evictions during this pandemic. We are presenting slides, but we would love to be a little interactive, so please share questions or comments in the chat. Amy, I'll just ask you to please monitor that for me while I present, and I'll jump in while you present. And if it makes sense, we'll interrupt one another and get those questions in right away. Otherwise, we can also save them until the end. So if we could go to the next slide, these are the topics that we're going to be covering today. We're going to talk about the Montana Eviction Intervention Program, MEEP, and why we do it and why it's important, why tenants need representation when they're being evicted, the 5 basic stages of a judicial eviction, some common housing issues and defenses during the pandemic. And then we're going to have a little discussion about an actual case that Amy had through this program. So next slide, please. So the Montana Eviction Intervention Program was established with CARES Act funding through Montana Housing at the Department of Commerce. There's also ARPA funding now to continue this program at least through the biennium, which is what we were approved for through the legislature. This funding allows MLSA to pay private attorneys to give advice or represent clients. So when this program first started with MLSA, we contacted attorneys who we thought might be interested in working in this program and had several sign up. We now contract with a network of private attorneys across the state who take eviction cases. We pay them what we call a low bono rate in order to take those cases. So when attorneys provide advice to tenants facing evictions, they speak to them on the phone for about an hour about their case, and they help them understand their next steps, filing dates in the eviction process, and answer any questions that they may have. Cases can also be referred for full representation, where an attorney can take on a case and help a client through the entire court process. Next slide, please. We currently have 16 attorneys actively taking cases and 5 attorneys doing advice calls. And we have an attorney who does both. Since October 2020, we have taken 120 eviction cases through me for full representation. So this represents about 185 adults and 120 children in Montana who were facing eviction. I just want to note, I pulled this data a couple of weeks ago and our numbers just continue to go up with the housing and rental markets being the way that they are right now. Evictions are still extremely problematic for folks throughout Montana. As probably many of you know, they're especially problematic in Missoula, Bozeman, and Billings, but really everywhere. We're seeing a lot of difficulties in the rental and housing markets everywhere. Next slide, please. So why is it important for tenants to have representation? I don't think any of the news on this slide is news to you folks. Most low-income tenants were already rent burdened prior to COVID-19. From 2012 to 2016, 3 out of 4 Montana renters were below the federal poverty line, and they spent more than 30% of their income on rent, which is considered definitely being rent burdened. In 2018, 1 in 6 American households spent more than half their income on rent. Many Montanans lost income due to COVID-19. For the week ending May 4th, 2019, Montanans had filed 6,720 initial and continued claims for unemployment. For the week ending May 2nd, 2020, that number jumped to 65,734. Needless to say, our housing and rental market has hit people very, very hard, and people who were already struggling in Montana. Next slide, please. MLSA is seeing many more requests for help from tenants than we did prior to March 2020. And representation can make a huge difference to tenants. One study found that without counsel, tenants are disruptively displaced 78% of the time. And with counsel, displacement can be avoided up to 95% of the time. It is very, very important for tenants to have an attorney so they understand their rights and they can try to keep their housing. Next slide, please. Eviction carries a lot of risks to tenants, including, they could be liable for holdover damages and attorney's fees that can be monumental. Eviction judgments, of course, can jeopardize their eligibility for subsidized housing and could be a barrier to finding future rentals. There are some differences if a tenant is living in a mobile home park, and there are differences if they own the mobile home and only rent the lot that they're living on. So if a tenant owns their mobile home and rents only the lot, the Montana Residential Mobile Home Lot Rental Act applies, rather than the Montana Residential Landlord and Tenant Act. So there are similar rights, duties, and remedies that are contained in both of these acts, but there's a couple of significant differences. And those have to do with the amount of time that an individual gets for notice. So if they're behind on rent for the lot only, it's a 7-day notice to pay or vacate. And for non-mobile renters, it's a 3-day notice. I'm sorry, if it's a mobile home owner, it's a 7-day notice. And if it's non-mobile renters, it's a 3-day notice. Where a lot only landlord can't terminate a month-to-month rental agreement for no cause. Next slide, please. So if a tenant does owe back rent, why should they bother with representation, or why should we bother trying to get them representation? The landlord, as the plaintiff, has the burden to prove the allegations of the complaint. So they do need to present evidence in court to support their reason for an eviction. A tenant may have counterclaims. Go ahead. Was someone jumping in? I'm sorry. Thought I heard somebody. Tenant may have counterclaims against a landlord, which offset the rent owed, such as the landlord's failure to make repairs. And this scenario is seen pretty frequently. So we really recommend that tenants talk to an attorney if they have concerns about repairs and they are being evicted, especially if an eviction comes soon after a request for a repair. Regardless of the circumstances, attorneys can often negotiate a settlement that will be the least disruptive to a tenant's life. This could include something like a more favorable move-out date to avoid an eviction judgment, or reduction in the amount owed, or a payment plan to avoid a monetary judgment. So I'm going to turn things over to Amy, who's going to tell us some more about the eviction process and what we are seeing with evictions during the pandemic.
Great, thank you, Rachel. And thank everyone for joining this session. You know, when I looked at the agenda of the conference, I am a participant in the conference. There were so many great competing sessions with our time slot. So I'm really surprised that so many folks have showed up for our session. So thank you for your interest in how to advocate for tenants and protect their tenancies in these incredibly challenging times. Let me just take a minute because we're kind of switching gears now and talking more about eviction law. So I want to go ahead and review the chat folder to see. It's great that everybody's introducing themselves and saying hi to the participants. Okay, on the bottom of the screen, I can click on the icon that looks like the projector screen. Just switch to PowerPoint. I'm sorry, I'm just not. I was hoping that Rachel would be in charge of our slides, so I didn't figure out how to do this, and I don't want to mess. Like,
why don't I?
There, I just clicked reading view. Let's see if that works. Then see the changes.
Can you see my slides now?
I'm still seeing mine.
Can you guys see mine?
Right now, it looks like it's still on the 5 basic stages of judicial eviction is the slide that's on.
Yeah, so that's my screen. We'll just go ahead. I apologize to you guys for not getting this figured out. Okay, there is a question from a participant. Are CBD flowers, smoking them, legal in federal housing? That's a really good question. You know, in federal housing, because federal housing is HUD funded, HUD requires that the tenant comply with federal law as to marijuana. So absolutely, tenants who are in federally HUD subsidized housing cannot use or possess marijuana, even if they have the state approved medical marijuana card. So the answer for marijuana is absolutely no. It's not legal for tenants to possess or use marijuana in federal housing, even with the medical marijuana card. But this question has to do with CBD flowers. My understanding is that CBD flowers do not contain THC, the active ingredient in marijuana. And it's the THC that's the psychoactive drug portion of the marijuana plant. So, you know, smoking CBD flowers may be a problem because all HUD housing that I know about is now non-smoking. You cannot smoke anything within HUD housing, whether it's marijuana or cigarettes or anything else. So I think the smoking of CBD flowers in HUD subsidized federal housing would be prohibited, but just possession of the CBD flowers may not be illegal. If you are working with a tenant who has questions about that, it's best to have them contact Montana Legal Services. And on our final slide, we'll tell folks how to make that contact. Because I haven't researched this issue specifically. I'm assuming that because folks without medical marijuana cards in Montana can buy CBD products on the market, so they're not regulated as controlled substances under federal law. And for that reason, my opinion is that, a federally subsidized tenant should be able to use or have CBD, possession of CBD products, including flowers, just not the THC part of that. But again, I would really like to do the research. So if you have a client who's facing that situation, please have them contact Montana Legal Services to apply for help. Okay, just scrolling through the chat. Next question, have you run into any circumstances where an older adult who rents gets evicted due to property management, selling property, and new owners have different plans for the property? I haven't particularly seen that. We do have another attorney at Montana Legal Services who specifically provides assistance to elder adults. Our attorney's name is Barb Harris. She may have seen that. I wouldn't be surprised if that is happening though. We are seeing all over Montana, properties are getting sold because our property values in Montana have gone up so much lately in the last year or so. So if you're a Montana landlord and you're not really interested in continuing to be a landlord, it's a great time to sell those properties, and we're seeing landlords sell those properties. So those sales affect the current residents in the building, whether they're older adult residents or younger adults. You know, all Montana renters are being affected if their buildings are being sold, if their rentals are being sold. So yes, I could certainly see that situation arising where a new property owner comes in. I just heard of one in Butte, for instance, and you know, those of you who've been in Montana for a while know that in Butte, you know, it hasn't been a particular hotspot for Montana renters crises. You know, Butte has had kind of stable housing and not huge demand from renters or landlords. But recently, I just heard yesterday of a building in Montana in Butte that had been owned by the same landlord, a native Montanan, for years, and an older couple had rented from them. Their only income is SSI. So they're on a fixed income. I think the total rent they did pay was $700. And then the owner of the building sold to an investor from California, and that investor has now raised the rent on a 30-day notice to these month-to-month tenants, which is perfectly legal, raise the rent by $400 a month, and they can't afford to pay it. So what is their legal option? Well, in Montana, we don't have any rent control that puts limits on how much a landlord can raise the rent at any one time. So what that means is tenants are facing either, you know, two really bad choices. Either agree to pay the higher rent and try to figure out a way to do that. And they can apply for rental assistance through the state and through Action East in Montana. And I see Steve Fournier is on the call. Hi, Steve. So there are options to apply for help with the rent, but that's not going to be long-term assistance. The only other option the tenant has is to move out and try to find a cheaper place to live, but that's not a great option right now because there just aren't any rentals available and prices are going up everywhere.
Hey, Amy, it's Rachel. I'm sorry to interrupt. We've got a couple of people in the chat who just have said it's hard. They're having a hard time hearing you.
Okay, let me turn my volume.
It's a little fuzzy and breaking up a little bit.
Okay, how is that? Is that any better? I've adjusted my volume.
No, it is not.
Well, it was working fine this morning. I don't know. I'm sorry.
You have to stay facing your microphone. If you turn your head, it'll make it muzzled.
Okay, well, my microphone is right at my mouth. And is my video showing?
No,
So let me
it might
undo-
be something with the headset.
You know, my video was on earlier. I could try logging out and back in. But since I'm the one doing the screen sharing. Oh, good. Yeah, I got my video. Thank you, Naomi. Our trusty host is helping me get back on video. Can you understand me now? Is the audio okay?
That does sound better.
Okay, I'll just try to speak really clearly. And I'm still going through the chat box for questions before we move on. So there's a question about where to find the document about medical marijuana. If you just do a Google search for HUD medical marijuana, it will pull up, it's a HUD opinion letter, basically, that says that even in states where medical marijuana has been approved or recreational marijuana, it's still not allowed by tenants in federally subsidized housing. Okay. Okay, and Rachel has put in our toll-free helpline number, the 1-800-666-6899. That's the number you can give to any client, a tenant or a different kind of client who wants to apply for legal services. Our services are free to those who are income eligible. And some of our housing assistance doesn't even have income eligibility requirements. So the best thing for everyone to do, if you know of somebody who needs help with any kind of legal problem, have them contact us to apply and let us figure out whether they're income eligible. Okay. So another question about a person who is smoking in their car in the parking lot of the rental property, I'm guessing. You know, in those situations, it's kind of a case-by-case determination, I hate to say, but the tenant needs to read their lease really closely, and whatever rule, sometimes it's in a house rule from the landlord that says there's no smoking. If the lease or house rules say there's no smoking on the parking lot or any property owned by the landlord, then the tenant probably can't be smoking inside their car if their car is on the parking lot. I hate for it to be that restrictive, but when the tenant signs a lease, that's a contract. So that's a binding agreement. And if it says they can't smoke in the parking lot or on any property owned by the landlord, then it's really risky for the tenant to be smoking even inside their car with all the windows up. And in the house, if the lease says there's no smoking in the house, that's a clear violation. So they definitely shouldn't be smoking in the house. If the tenant is not receiving federal housing assistance, can they smoke in their unit? That all depends on the contract they sign, whatever the lease says. If the lease does not prohibit smoking, then yes, they can smoke inside. But most leases, a lot of leases do now prohibit. Okay, we got a lot of questions, so that's great. We were hoping this session would be interactive. And I think we've still got time to go through the rest of the slides, so you'll have more of an overview of landlord-tenant law. Moving the mic down a bit, I'll try that. Somebody's asking about whether tenants are feeling a false sense of security, thinking they can't be evicted for any reason because of the CDC moratorium, and we have seen that too. Please, if you take nothing else away from this training this morning, please know that we have a bunch of resources about the CDC moratorium and other tenant rights posted on our website, which is montanalawhelp.org. And that information is up for anyone to access. So if you have a client who's telling you, I know I can't be evicted, even though, you know, I destroyed the plumbing in my house by flushing toys down the toilet, you know, whatever it is, if they think they can't be evicted because of the CDC order, that's just not true. The CDC order in its most limited application only applies to evictions based on non-payment of rent. So other grounds based on tenant culpability, things that they've done wrong, they can be evicted and the CDC order doesn't apply. But we'll get into that a little bit. What about residents that are in LI tax credit housing that are receiving Section 8 assistance? The HUD prohibition against medical marijuana applies in Section 8. So it also applies in the tax credit property. Okay, great. Yes, Erin makes a great point that, you know, we can all give legal information, not legal advice, but legal information to our clients who are tenants. But you definitely want to caution them about the risk of forcing the landlord to file an eviction lawsuit against them in court to remove them from the premises. If that happens, if the landlord files a lawsuit against the tenant for eviction and the tenant loses, then if the tenant has any kind of rental subsidy, like a Section 8 voucher, they risk losing that Section 8 voucher because they were evicted by a landlord who was accepting Section 8. So it's always good to caution tenants about staying past the date in a landlord's notice to terminate their tenancy. Yes, tenants have the right to stay if they think they have good defenses to the eviction. But, you know, once the case gets filed in court, no one knows how the judge or the jury will view that case. Even if we think the tenant has really strong defenses, we're not going to be the judge or the jury. And they get to decide if they rule in the landlord's favor, the tenant risks losing Section 8 voucher. Another question about medical marijuana, big topic in my opinion. What if the tenant says they will not use in or on the assisted property and they still have a Section 8 voucher? So HUD does give some discretion to landlords to decide how strongly to go after medical marijuana users. The landlord has some discretion. There may be some landlords who decide it's okay if the tenant just uses off the property. Technically, if you read the HUD rules, you can't possess or use anywhere, not just in your property. So if the landlord chooses a strict reading of the HUD rules, then even if the tenant is only using and keeping their marijuana at a friend's house or their parents' house or something and only using there, technically, because they're still in violation of the federal law, which criminalizes possession of marijuana, they could still be evicted. Remember, the marijuana use and possession in HUD housing is governed by federal law, which prohibits marijuana and makes it crime, not by Montana law, which now approves recreational and medical marijuana. So it's risky. If you have a client who has a medical marijuana card, it's best to tell them not to use or possess at all if they want to keep their federal housing. That's the clearest answer. And then it's up to the client to decide whether they want to risk it by using off premises. Okay. Okay, there's a question about once the COVID-19 moratorium, ends, so the CDC moratorium ends right now, June 30th of this year. What is the most common best answer for tenants to file after being served? You know, there are all kinds of answers to that question. There's not one boilerplate answer that a tenant could file to try to defeat the eviction. It depends on their own circumstances. Yeah, and like Rachel said, we have some great resources on Montana Law Help about potential defenses. And also, we are here for tenants at Montana Legal Services. So please refer individual clients to us if they've gotten a notice of termination from the landlord or if they've been served by a process server with an actual eviction for that's filed in court. Please refer those folks. Okay, so that's it for the chat for now. I will go back to it as we go through these slides, but thank you everyone for the questions. It's great that everybody's so interested in this topic. Okay, so now let's talk about the legal aspects of eviction in Montana. What is the process a landlord has to go through if they want to remove a tenant from the rental? So the first step is the landlord has to give the tenant a notice to vacate. All that is a letter. It can be hand delivered to the tenant. It can be mailed. It doesn't have to be mailed by certified mail. It certainly doesn't have to be served by a process server or a sheriff's deputy. Also, text messages and emails to the tenant may be valid. We have an electronic communications act in Montana that says when any statute requires the notice to be in writing, which the landlord tenant statutes do require notice of termination to be in writing, but the Electronic Communications Act says that anything required to be in writing is considered to be in writing if it's sent by electronic means. So a text or an email is likely sufficient as a notice of termination. Most landlords are still using written notices, though, as far as I can tell. Okay, so let's just use a specific example. Let's say the landlord gives the tenant a notice saying, you have 3 days to vacate, you're behind on the rent. If you don't pay, let's say it's $1,000 owed in. You have 3 days to pay that $1,000 or move out. So let's say the tenant gets that notice, they don't have the $1,000 and they weren't able to get rental assistance, but they don't have a place to move, so they stay past the 3-day notice. What happens? Then the landlord has to take the next step. And the only legal option the landlord has at that point is to file an eviction lawsuit against the tenant in court. Okay, so the landlord cannot just shut off the client's utilities to try to force them to move. cannot shut off their utilities and cannot change the lock. The landlord cannot legally do anything to force the tenant out of the rental except to file the eviction lawsuit. So that's one good thing for tenants to know, because they think if they stay past the deadline in the landlord's notice, they may be taken to jail or suffer some kind of criminal charge against them, but that's not true. The only thing that will happen legally is the landlord to file an eviction lawsuit in court. Okay, so after the tenant is served with those court papers, and that means that a process server or a sheriff's deputy will come physically hand deliver copies of the court papers to the tenant. Those papers will say right on them that the tenant has 10 days to file a written answer with the court to say whatever defenses they have to the eviction. So it's really important for tenants to file their answer within that 10-day period. And that's 10 days that don't include Saturdays, Sundays, or legal holidays within that 10-day period. The summons on the eviction papers will not say, unfortunately, that there is the possibility that if the tenant cannot afford the answer fee, there's a $30 answer fee that is expressly stated right on the summons. If you file an answer, you have to have $30 to pay to the clerk of court for filing the answer. What I wish the summons would say, but it doesn't, is that if the tenant cannot afford to pay that $30 fee, they can still file their answer. They just have to fill out an extra piece of paper for the court to say what their income and expenses are, so that hopefully the court will review that and say that they don't have to pay the $30. So please, if you're hearing from clients that they've been served, that what are they going to do? They don't have the $30 to file an answer. Tell them to go to the clerk of court's office and tell the clerk they don't have the $30, but they still want to file an answer, and the clerk will give them the affidavit. They can also find it, it's a declaration form now, not an affidavit. They can also find that form on montanalawhelp.org. Okay, so the tenant files their answer. Then what happens? The court will set a hearing within 10 days of when the tenant files their answer. Sorry, it's within 14 days after the tenant files their answer. There will be a trial date for the tenant to show up and the landlord to show up, and that's when the judge will hold the hearing. First, the judge will hear the landlord's side of the story and why the tenant should be evicted. Then the tenant gets to put on whatever the defenses are, including the CDC moratorium, if that applies. And then the judge will decide the case and whether the tenant is evicted or not. So usually the courts don't tell the parties who are in court at trial what the judge's decision is. The judge prefers usually to take it under advisement, think about it for a few days, and then issue a written decision which gets mailed to the tenant and to the landlord. If the landlord rules, if the judge rules in the landlord's favor, then the judge signs an order of possession saying by what date the tenant has to move out. So it's in the written decision where the judge will say how many days the tenant has to vacate if the judge rules in the landlord's favor. The judge also signs a separate written document called a writ of possession that is directed to the sheriff's office, telling the deputy that they can go remove the tenant from the rental premises by force if the tenant has not vacated by the date the judge says they have to move out. And then, so if the tenant moves out before the date that the judge stated, then the writ will never be served on the tenant because they moved out by the deadline. But if they don't move out by the judge's deadline, then the sheriff comes over with the writ of possession and forces the tenant to leave the rental. So that's a really bad conflict, to say the least. Okay, moving on. Okay, so these are some of the common defenses and counterclaims that can be raised for tenants. Sometimes the landlords don't do the notice of termination properly. They don't give the required number of days to vacate. And now there's an extra protection that was issued in the federal legislation called the CARES Act back in March of 2020 that says that before a landlord who was covered under the CARES Act can evict a tenant, they have to give a 30-day notice, even if it's for non-payment of rent, which in Montana usually only requires a 3-day notice. If this landlord was federally covered, which we'll get to in a couple of slides, they were covered by the CARES Act, they have to give the tenant 30 days notice before they file the eviction lawsuit. So that's a defense. If the tenant didn't get that kind of notice, the tenant can raise that as a defense to the eviction once they are served with court eviction. Other defenses are that the court action violates the CDC moratorium, which we'll talk in more detail about, that the landlord has failed to make repairs, that the landlord did shut off the tenant's utilities or change the locks prematurely. Those are all defenses that can be raised for the eviction lawsuit. If the landlord uses unconscionable lease terms, you know, for instance, if they say you're going to be charged $100 if the landlord has to send you a notice of violation in the mail, that could be considered unconscionable, and the tenant can raise a counterclaim about that. Or if the landlord has prohibited provisions, that's another counterclaim. The landlord may have failed to provide essential services like utilities or garbage service, or maybe retaliating against the tenant for requesting repairs. That's the defense to eviction. So if a tenant has requested repairs within 6 months before the landlord pursues the eviction, and let's say the eviction is for no cause, just here's your 30-day notice, you're a month-to-month renter, I want you out. But if the tenant has requested repairs that affect health and safety within 6 months before they get that 30-day notice, that could be a defense. They can claim that the landlord is really retaliating against them and seeking their eviction because of their request for repairs, not just because of the 30-day notice. They can also raise discrimination. If they think they're being discriminated against and the landlord's only evicting them because they're a person with disabilities or because of their race, religion, sex, age, any other protected class, that can be a defense. Okay, so the two main defenses right now related to the pandemic are the 30-day notice that's required under the CARES Act for any landlords who were federally covered by the CARES Act. We'll get to federally covered in just a few slides. Then the other biggest protection, which most folks are familiar with, is the CDC moratorium. The CDC has put a temporary halt on evictions that started back in September of 2020. The deadline has been extended in increments. It currently expires on June 30th. But to be covered by the CDC moratorium, the tenant has to take affirmative action by submitting their declaration under the CDC order, which is available on our website, in the full website. So which buildings are covered by the CARES Act? Which landlords have to provide the 30-day notice of termination? The CARES Act only applied to properties with federal financing, so loans that were securitized by Fannie Mae or Freddie Mac, or properties that participate in federal housing programs like HUD programs, USDA rural development, LIHTC tax credit properties. All of those landlords have to provide the 30-day CARES Act notice of termination. So it covers quite a few of our landlords in Montana. But it's difficult for tenants to know for sure if their landlords have mortgages secured by Fannie or Freddie. So that's the one downside to figuring out who's covered by the CARES Act. But just know that all federally subsidized landlords are covered. And for those landlords who have some, maybe they don't get an overall subsidy for the building, but if they rent to any Section 8 tenant, the entire building is covered by the CARES Act because they have a federally subsidized tenant living within the building. So they do have to comply with the CARES Act and get the 30-day notice of termination. Okay, so last summer, you may remember the CARES Act did put a moratorium on eviction through July 25th of 2020. Now that moratorium is gone and the CDC moratorium is in place, but the 30-day notice required by landlords under the CARES Act is still in effect. So it's a really important protection for tenants. Okay, there's some more detail about who's covered. A federally covered property. I'm going to skip over that since we're getting a little short on time. Let's talk more about the CDC order. So what does it do? It puts a temporary halt on residential evictions to prevent the spread of COVID-19. It applies to all landlords, not just federally subsidized landlords. It prohibits a landlord from evicting any covered person, and a covered person is someone who submits the written declaration to their landlord. Prohibits them from evicting them from any residential property where the order applies, and it applies really broadly. Which of our tenants qualifies for this protection? So it has to be a tenant, lessee, or resident of residential property. If the tenant is renting the building for their bakery or some other commercial purpose, they're not qualified for the eviction protection by the CDC. They have to submit the declaration, and the declaration contains 5 key elements. They have to say that, truthfully, that they use their best efforts to obtain all government assistance for rent or housing. So they need to apply for the Montana Emergency Rental Assistance Program that's now up and running again. They have to meet the income limits, which a lot of our tenants in Montana do meet those requirements. They have to be unable to pay their full rent due to a substantial loss of household income or extraordinary medical expenses. The important thing about this element is it doesn't say the loss of income has to be COVID related. So a landlord cannot require the tenant to show that their loss of income is COVID related. And even if they don't have a substantial loss of income, they may still qualify under element 3 if they have extraordinary medical expenses. And those medical expenses do not have to be related to COVID. Okay? The bummer about element 3 is if you've got clients who are on a fixed income, like SSI, and they don't have extraordinary medical expenses, they're not likely to have a substantial loss of household income, and that makes them ineligible to invoke the CDC protection. So that's a huge downside to the CDC declaration. Okay, so the 4th element in the CDC declaration is the tenant has to be using their best effort to pay whatever amount they can afford to pay to the landlord per month, and that they would likely become homeless or forced to live in close quarters or shared housing if evicted. So if you ever have a tenant who owns property somewhere that they're not living on, like I actually talked to a tenant recently who was living in a rented mobile home, but she owns a home in Sealy Lake that she's got on Airbnb, and she doesn't want to move into that house because she's making income from it. But technically, she would have the option to move into her own house. So she likely doesn't qualify to invoke the CDC protection if her landlord in the mobile home gives her a notice to vacate. So the important thing about the CDC declaration for all of us to know is that the tenant who signs it is swearing to the truth of the statement made in the declaration. So if the tenant knows that one of those statements is not true for them, one of these 5 elements, they should not sign the declaration. They can still defend against the eviction in court if they have other defenses, but they should not submit the declaration. Okay, so does the CDC order halt all evictions? The answer is no. If the tenant has done some kind of lease violation, like those listed on the slide, criminal activity, threatening health and safety, damaging property, violating any kind of building code or health ordinance, or violating any other contractual obligation in your lease, then the landlord has grounds to evict them, even if they have submitted the CDC declaration. So technically, the CDC declaration only applies to evictions based on non-payment of rent. I think, and other attorneys think, that there's an argument that can be made to a court that the CDC order should also protect tenants who are being evicted at the end of their lease for no reason, or on a 30-day notice for no reason. Because the overall public policy considerations of the CDC order are to keep people housed during this pandemic, to curtail the spread of the virus throughout all of our communities, and folks are homeless and doubling up with relatives or friends. So the public policy considerations apply to those no cause terminations, and we don't have any court decisions yet on those cases, but I think there's an argument to be made that those tenants may be covered by the CDC moratorium, even though technically by its own terms it only applies to evictions based on non-payment rent. If the tenant makes those kind of arguments in court, then it's up to the judge to decide how to apply the law and the CDC order to the particular facts presented in that eviction. Okay, so we already covered that slide. So I just wanted to give you a specific example about what eviction case where the tenant's getting assisted through our Montana Eviction Intervention project, what that kind of case might look like. So again, the MEET project through MLSA is a joint project through MLSA with funding from Montana Housing, the Montana Department of Commerce Housing Division, federal funding they got through the CARES Act. Montana Housing realized that tenants needed attorneys to fight these evictions in case there were defenses that they could raise. So Montana Housing gave some of the funding under the CARES Act to Montana Legal Services to start this MEET project. And now our cooperating attorneys throughout the state are helping them fight these evictions. It's not just us legal aid. Okay, so let's talk about what one of those cases is. So mom contacts Montana Legal Services. She has one child and she admits she owes rent from last fall. Now, the landlord in this case is savvy and knows that the CDC order clearly halts all evictions based on non-payment. So they're not going after the tenant for a non-payment eviction. Instead, they base their eviction on 2 disturbances that they claim happened, one in December of 2020 and one in February of 2021. So the landlord sends the tenant a notice saying, you are being evicted because you created these disturbances on 2 different occasions. And under Montana law, it's true that it says that if you have a repeat violation within 6 months, the landlord just has to give you 5 days notice and you have to move out. And if you don't move out, the landlord can file an eviction lawsuit. So what do you think happened at this trial? It's not based on non-payment rent, but in the lawsuit, the landlord does say tenant owes, I think it was like $450 in rent, but that's not what this eviction is based on. It's based on this disturbance. So let's take a poll. What do you think happened at the trial? And I think, Naomi, can you tell me when the poll answer you were in?
Okay, let me see. We're looking for the poll. I should have looked for that before. beforehand. Let me look. Okay.
Well, I'll just go ahead and move on because we're running short of time.
Yeah, let me take a look. I'll keep looking, but go ahead.
Okay. So basically, the end result of this eviction, and the client was a Section 8 voucher participant, so the risk to her was huge, right? She's facing an eviction for these two alleged disturbances. She and her daughter would be homeless if they didn't prevail in the eviction, and they would likely lose their voucher. But what the judge decided in the case is that the landlord failed to prove the two disturbance issues, failed to prove that the tenant was responsible for those disturbances, because in the February disturbance, the tenant's abuser is the one who was knocking on the door and creating this disturbance. She wasn't even home. She was out of town, but the abuser created this disturbance and a neighbor complained. So the judge, rightly, in my opinion, found that the tenant wasn't responsible for that, had no control over him there knocking on the door. She wasn't even home, didn't invite him over, because she was gone the whole weekend. So the tenant got to stay and was not evicted, but the judge did find that she owed the $450 for rent. So she's applying for rental assistance to get that rent covered. So it was a great result for the tenant. She kept her vouchers, she kept her Section 8 voucher rental. She's still living there with her family. She's just figuring out a way to get her rent paid. So that's just an example of how tenants do have defenses to these evictions, which is good. But sometimes they need a lawyer to raise those defenses. So please refer to clients. Okay, final pages, just link to our Montana Law Help webpage. They have a whole ton of resources, how to apply for help. Basically, I think can apply through our website if they want to apply online. They can also call our toll-free number. You can contact Rachel if you have more questions about the new project and all the great work that private attorneys are doing under that project. And you can also contact me. My email is ahall@mtlsa.org. My inbox is so overwhelmed right now with eviction-related cases, though, so it's probably better for you to contact me. Okay, I'm just going to take a quick look at the chat. But I think our session is over. I really appreciate the participation. It was great to have this session.
Okay, great. Thank you, Amy and Rachel. And thank you everyone for joining us for this session. Remember that everyone can always participate in the community conversations more on these issues through the Whova app to chat some more. We will now be on a 1-hour lunch break, and we look forward to having you back in our breakout sessions at 1 p.m. Rachel, was there something you want to say before we wrap it up?
No, I just wanted to say thank you, everyone, for coming and participating, and please reach out if you have more questions.
Yes, thank you, everyone. We appreciate you and have a great conference.
Thank you, Naomi.
Thanks, guys.